It's a scenario we can all picture, right? Someone convinces you to sign on the dotted line based on something they said, something that turns out to be totally untrue. And because of that, you end up losing out. Well, the contract law of England and Wales has a really powerful framework for exactly this situation, and it's all about misrepresentation.
Well, in this explainer, we're going to get laser focused on its most serious form, fraudulent misrepresentation.
This video was created with AI to support SQE1 study. We are independent and have no affiliation with the SRA, Kaplan, or the SQE. We do not share exam content, and our videos are for informational purposes only and should not be used as legal advice. Please check and refer to primary legal sources and recommended prep guides as you study.
Okay, here's our game plan. We'll kick things off with the basics of what misrepresentation even is, then we'll zero in on the really specific legal test for fraud. After that, we'll cover what you actually need to prove, look at the remedies, which are huge, and then wrap it all up with the key takeaways for your exam.
Right, so before we jump into the deep end with fraud, we've got to lay the groundwork. Let's start by getting our heads around the broader legal concept of misrepresentation itself.
So think of it like this. For any misrepresentation claim to even get off the starting blocks, you need these three key ingredients. First, an untrue statement of fact. Second, that statement had to be the thing that actually convinced the other party to get into the contract. And third, the person making the claim must have actually lost something because of it. Now, contract law basically sorts misrepresentation into these three buckets. And which bucket it falls into depends entirely on the state of mind of the person who made the statement. You've got negligent, which is about carelessness, and innocent, which is basically an honest mistake. But today, we are tackling the big one, the most serious of the three, fraudulent misrepresentation, because this one involves actual dishonesty.
So what is it that elevates a simple false statement to the level of legal fraud? Well, the answer isn't in some brand new law. It's in a landmark case from the 19th century that, believe it or not, is still the absolute authority on this today.
And here it is. This right here is the legal test for fraud laid down in the famous case of Derry v. Peake. If you're studying for the SQE, you have to know this definition inside and out. And as you can see, it sets a really, really high bar for anyone trying to prove fraud. So this test gives you three different paths to proving fraud. And a claimant doesn't have to prove all three. Just one is enough. You see the common thread here, right? Each one of these points to a dishonest state of mind. This isn't about just being wrong or even a bit sloppy. It's about a deliberate lie or just not caring at all if it's true or false.
Okay, this is a super important point for your exam. In the Derry v. Peake case itself, the company directors said in a document that they had permission to use steam trams. The reality? They just honestly thought getting permission would be a piece of cake. Because their belief was genuine, even if it was a bit daft, their statement wasn't fraudulent. Honesty, you see, is a complete defense.
Okay, so we've established that proving the defendant's dishonest state of mind is the biggest challenge. But what are the other building blocks a claimant needs to put in place to build a successful case for fraudulent misrepresentation?
So, on top of proving dishonesty, a claimant has to nail down these four pillars. We've touched on a few, but let's dig into one of the most common exam traps, the difference between a statement of fact and just a simple statement of opinion.
As a general rule, a statement of opinion won't get you anywhere. In Bissett v. Wilkinson, the seller's statement was just an honest guess. He didn't know any better. But the law carves out a crucial exception. In a case like Smith v. Land, where the person giving the opinion is in a much better position to know the real facts, their opinion can actually imply a statement of fact. I mean, saying a tenant is desirable when you know full well they haven't paid rent in months, yeah, that crosses the line into a misrepresentation of fact.
So, let's say a claimant manages to prove all the elements. They've jumped through all the hoops. What happens next? Well, this is where we see the real teeth of this claim, in the powerful remedies the law offers up.
This is absolutely critical. You see, for the other types of misrepresentation, the claimant might have to choose their remedy. But for fraud, the law says the wronged party gets the best of both worlds. They can unwind the contract completely and get financial compensation for their losses.
Think of rescission as a giant undo button. You're effectively hitting reset, treating the contract as if it never even happened. To do this, the innocent party has to tell the other side, hey, I'm rescinding. The whole point is to put everyone back to where they were before the contract was made.
But, and this is a big but,
That right to hit the undo button doesn't last forever. It can be lost if one of these 4 bars to rescission pops up. For instance, if you find out about the lie but decide to just carry on with the contract anyway, you've affirmed it. Or, like in leafy international galleries, if you just wait too long. Memorizing these 4 bars is non-negotiable for the exam.
Now, here's a more advanced point. Usually, common law rescission doesn't have a time limit, but things can get tricky if you can't restore things exactly as they were and you need the flexibility of equity. Well, the recent case of HMRC v. IGE confirmed that a claim for equitable rescission for fraud actually has a 6-year limitation period. It's a subtle point, but it could really make your answer stand out.
And what about the money? The damages? For fraud, they're awarded under the tort of deceit, which just shows you how seriously the law takes this. The claimant can get back all of their direct losses from the fraudulent act, even if those losses were totally unforeseeable. This is way, way broader than what you'd get for a standard breach of contract.
Okay, I know that was a lot of detail. So let's pull it all together into a nice, clear comparative table. Honestly, this is the perfect slide to screenshot for your revision notes.
This table is pure gold. Just look at the key differences in that fraudulent column. The state of mind is dishonesty. The burden of proof is on the claimant to prove it. And crucially, the remedies are rescission and those extensive damages in deceit. Now compare that with negligent and innocent misrepresentation. You can see why succeeding in a fraud claim is such a big deal. So, let's lock in the crucial points. You've got the tough 3-part Derry v. Peek test for dishonesty. You've got the powerful 1-2 punch of rescission and damages as remedies. And finally, remember this absolute rule. A party cannot write a clause in a contract to get out of being liable for their own fraud. Any attempt to do that is completely void. I'll leave you with a final thought to chew on for your studies. This question really gets to the very heart of that Derry v. Peek decision, and it's all about that fine line between a deliberate, actionable lie and an honest, even if it was a bit unreasonable, mistake. If you can master that distinction, you are well on your way. Thanks so much for joining me for this explainer.